Thank you. The Vice Chancellor, Professor Henry Kiplangat. And when we recognize our Vice Chancellor, we have recognized everyone in Kabarak because we serve under him. Professor Justice Willy Mutunga, the Emeritus Chief Justice of the Republic of Kenya, and Professor of Public Law at Kabarak University Law School. Professor Louis Franceschi, Senior Director, Governance and Peace at the Commonwealth of Nations, who is privileged us with his presence. Louis Franceschi is also my mentor and personal friend. Members of the legal fraternity who are here, the academic community, if you permit me to recognize the Dean, Kisii University Law School. Permit me also to recognize Professor Sylvie Kangara, who will be speaking much later, and all the members of Kabarak University Senate, staff and students, distinguished guests, ladies and gentlemen. Permit me to read a speech, something I rarely do. I usually speak off the cuff. And I've also done something unusual, which is to have a title for my speech. It's very brief though. It's called The Leopard Has Given Birth. Again, if you permit me, let me commence by thanking our Vice Chancellor, Professor Henry Kiplangat, for making this milestone possible. I'm sure you will know that this is the only the third inaugural lecture in the history of Kenya's law schools. And law schools in Kenya have been there for the last 50 years. So it's not a small milestone, and we are taking it seriously. Thank you very much, Professor Kiplangat, for lifting us that up. Permit me also to congratulate Professor Willy Mutunga for reaching these incredible heights. I already have mentioned that this is not normal. After that, allow me to start by making a declaration. I consider it a very important declaration to declare that today is an important day. That's simple but very important. I remember that as a young man growing up in the village, I witnessed some unique days. There were days when I went outdoors only to find that the sun was shining brightly, and at the same time, the rain was raining. Okay? On such days, my mother, now late, Elizabeth Adenyi, would pronounce that Ingweivule. In my language, it means the leopard has given birth. And that would be enough explanation those days. Okay? Today, we don't have that scenario. The rain is not raining simultaneously with the sun. But I still declare this a great day. Why do I say so? The answer is because it is because we are on the brink of a rhetorical moment. My friend and mentor, Mr. Kennedy Buhere, taught me once that a rhetorical moment crystallizes when you have three key ingredients happening. One, you have a great person of history. Two, you have a great occasion. And three, you have a great oration. Okay? And I believe those things are here, crystallizing very well together. As you already know, Professor Mutunga requires no introduction. He is easily the most accomplished and decorated academic serving in any university in the world at the moment. I'm sure that is obvious. He is the Akulu of the law. If you don't know what Akulu is, he's the ancient of the law. Okay? My people would happily call him Omsahulu, Mzee wa Sheria, isn't it? That is what Willy Mutunga is. Additionally, an inaugural lecture is a great occasion in and of itself. It is a moment to crown decades of scholarship and to do so publicly and braggingly. Okay? It's also a moment to imbibe the Akulu's ideas, gleaned from decades of rigorous scholarship. You know, Willy has been in this thing for probably 5 decades, and we are here to just imbibe the wisdom in a short time. Because the great man is about to meet a great occasion, and to solemnize it with a great oration, the leopard has given birth. And so it's a great day. I hope you agree with me. Okay? And if I was to speak literally, the leopards of Kabarak are not about to engage the services of family planning experts. They will continue to give birth. We shall continue to have great occasions here every other day. Right here today, we're also launching the first publication of the Kabarak University Press. And this is Willy Mutunga's lecture published as an occasional paper. Okay? So it is another great day in another great day. A play within a play, so to speak. Later this year, you will see very, very many books coming out from the press, and we shall be asking you to come and see the sun shining and the rain raining at the same time. We are revamping our legal aid programs this year at the law school. We are revamping our ADR programs. In fact, we shall be launching an alternative dispute resolution center. And even more seriously, this year, you expect that we will be launching 2 world-class master's programs and a doctoral programs at the same time. Just last year and this year alone, we've been able to get 4 professors teaching at the law school. And that tells you our intentions. They're quite clear. So be prepared to come and witness the leopards give birth, and that is the direction that Kabarak is headed. I think it is not my day, and I think it is time to stop. But before I do that, again, just to thank my Vice-Chancellor for the job well done, for steering our university to great heights. If you just saw what has happened already, then I think that is testimony of where Kabarak stands. Allow me also to congratulate my mentor from childhood. I've always told Professor Willy Mutunga that his picture was on my wall as a boy. Willy, the picture with the Zambian High Commissioner, I've always reminded you about that picture. It was on my wall as a 10, 12-year-old boy, or 13-year-old boy in my Simba. And just because he was my mentor in issues of governance, rule of law, and constitutionalism. Okay? And thank you all for gracing this occasion, a historical occasion that only you will live to tell, because these ones are few and far between. Thank you very much, and may God bless all of you, and most importantly, also Kabarak University. God bless you. Before I sit, permit me to invite my supervisor, Professor Chepkilot, who is the DVC in charge of administration and finance, to come and also address you. Thank you. Thank you, sir. Okay.
Thank you, Professor Ambani. Our Vice-Chancellor, Professor Henry Kiblangat, our Chief Guest, Professor Justice Willy Mutunga, our guest also who's visiting with us, Professor Louis Franceschi, members of management, members of Senate, invited distinguished guests, members of staff, students, ladies and gentlemen. My duty this morning is to invite the Vice-Chancellor to make his remarks. But before I do so, I would like to make a few remarks. I wish to take this opportunity to congratulate Professor Mutunga upon his appointment as Professor of Law at this great institution. I also wish to salute him on this auspicious occasion of presentation of Inaugural Lecture, where he will be able to give us insights into his scholarly work. Professor Mutunga, you are joining Kabarak University as elicited a lot of excitement in this institution, particularly in the School of Law. The students and staff are looking forward to benefiting from your immense legal experience and research work. The students and staff are also looking forward to your mentorship and guidance in the area of law. Ladies and gentlemen, what distinguishes a world-class university from the rest is the caliber of its faculty. Your appointment, Professor Mutunga, in this institution has taken this university a notch higher, and we are very happy that you took up the appointment. I would also like to take this opportunity to thank the Vice Chancellor for making this occasion possible. And ladies and gentlemen, I would like now to welcome our Vice Chancellor, Professor Henry Kiblangat, to come and make his remarks and also read the citation of our chief guest, who is Professor Willy Mutunga. Join me in welcoming. Let us give him a hearty welcome. Welcome, sir.
The legal fraternity, the academic community, members of Kabarak University management, University Senate, staff and students, distinguished guests, ladies and gentlemen, good morning. On 1st October 2021, Kabarak University Governing Council, in accordance with the university staff terms of service and appointments, appointed Dr. Justice Willy Mutunga, former Chief Justice of the Republic of Kenya, as Professor of Public Law, Kabarak University School of Law. The appointment constitutes a return of Professor Justice Willy Mutunga to the Academy, having previously taught at the University of Nairobi from 1974 to 1982. Ladies and gentlemen, this is a historic moment for Kabarak University to host the first inaugural lecture in our successful 22 years of existence since the founding of this university in 2000 by His Excellency Honorable Daniel Toroitich Arap Moi, the second President of the Republic of Kenya. It is with a profound sense of appreciation and gratitude to God that I welcome you to this inaugural lecture and thank you for your in-person and virtual attendance. Ladies and gentlemen, like all the other 6 schools in the university, the Kabarak University School of Law, launched on 25th June 2010 by His Excellency President Moi, was a brainchild of His Excellency President Moi. And this inaugural lecture is therefore sufficient proof that the Kabarak University School of Law has come of age. For Professor Justice Mutunga, this inaugural lecture is a crowning moment for nearly 5 decades of innovative and productive scholarship. I am therefore greatly honored to present a brief glimpse into his prolific academic life, and distinguished achievements. On his education, Professor Justice Willy Mutunga earned his Bachelor of Laws degree from the famed Faculty of Law at the then University of East Africa, Dar Law School, in 1971. He later returned to Dar es Salaam and completed his Master of Laws degree in 1974. In 1992, he earned his Doctor of Laws in Jurisprudence degree from Osgood Hall Law School, York University, Toronto. And in his doctoral research, titled Relational Contract Theory Outside National Jurisdictions, he developed a theoretical framework which he called a jurisprudence of basic need for all people. His publications: Professor Justice Mutunga has authored over 60 scholarly publications. These include 4 first-author books: The Rights of Arrested and Accused Persons, published in 1990, Constitution Making from the Middle, Civil Society and Transition Politics in Kenya, 1992 to 1997, first published in 1998, and the second edition was published in 2020. The Studied Justice, a memoir that's a forthcoming book to be published this year, and Transformative Constitutions and Constitutionalism, a new theory and school of jurisprudence from the Global South. That is a book that is forthcoming to be published this year. Additionally, Professor Justice Mutunga has published 8 co-authored books and 39 articles in journals and legal magazines, 7 of them being chapters in books. He has also presented 44 unpublished lectures and papers at conferences and seminars. Professor Justice Mutunga was a columnist in the Saturday Nation and Sunday Nation from 2004 to 2011 under the pen name Cabral Pinto. A compilation of these writings will be published in book form. His call to the bar. Having been called to the bar in 1972, Professor Justice Mutunga served as chair of the Law Society of Kenya from 1993 to 1995. In the preceding decade, after he was released from political detention in 1983, he litigated in general practice. His awards: in 1998, Professor Mutunga was awarded the first Law Society of Kenya Distinguished Services Award for Constitutionalism, Rule of Law and Human Rights. In 2003, he was appointed senior counsel, and on August 19, 2016, he was awarded the Law Society of Kenya Award for Distinguished Service in the Administration of Justice. His civil society engagements. Professor Justice Mutunga established and served in several civil society organizations, including the Legal Advice Center, Kituo cha Sheria, the Law Society of Kenya, Citizens Coalition for Constitutional Change, the 4 Cs, Kenya Human Rights Commission, East African Center for Constitutional Development, Kituo cha Katiba, Uganda, and the International Center for Human Rights and Democratic Development, Rights and Democracy in Montreal, Canada. In addition, he served as program officer, later regional representative and head of office for Ford Foundation East Africa from 2004 to 2008, and later on from 2008 to 2011, during which he helped support civil society work in advancing democracy, rule of law, and the arts. His national and international honors. For his many achievements, Professor Justice Mutunga has been the recipient of national and international honors and awards for contributions to the development of law, human rights, good governance, and social justice. These include Senior Elder of the Golden Heart in 2014, Elder of the Golden Heart 2010, Senior Counsel, Government of Kenya since 2003. In 2003, lifetime achievement. I was reading his national and international honors, and for clarity, let me repeat this part. For his many achievements, Professor Mutunga has been the recipient of national and international honors and awards for contributions to the development of law, human rights, good governance, and social justice. This includes Senior Elder of the Golden Heart 2014, Elder of the Golden Heart 2010, Senior Counsel, Government of Kenya 2003, Lifetime Achievement Award for the protection and promotion of human rights from the Kenya National Commission on Human Rights 2003, the Jurist of the Year Award from the International Commission of Jurists, Kenya Section 2003, and the Law Society of Kenya Distinguished Services Award for Constitutionalism, Rule of Law, the Human Rights, later named the Father Kaiser Award in 1988. Ladies and gentlemen, you will agree with me that the academic community, the legal fraternity, and the general public deserve to listen to Professor Justice Willy Mutunga's inaugural lecture. It is now my singular pleasure and honor to welcome Professor Justice Willy Mutunga. Ladies and gentlemen, please help me welcome the distinguished scholar. Thank you very much.
The Vice Chancellor, Professor Henry Kiplagat, Professor Louis Frashensky, Senior Director, Governance and Peace, the Commonwealth of Nations, the legal fraternity, the academic community, members of the Kabarak, Senate, staff and students, distinguished guests, gentlemen and ladies. Ladies and gentlemen, sorry. I'll start reading this inaugural lecture for about 10 minutes, and you will excuse me because I will have to deliver the rest of it while seated, because I have a back problem. I can't stand for 1.5 hours. Sorry. The structure of my inaugural lecture falls within the trajectory of my personal experiences in search and defense of radical legal education for over 5 decades. I will not dwell on what radical legal education is at this juncture. The elements of this education, rather than definition, will be gleaned from the trajectory of the inaugural lecture. Indeed, I'll come up to this issue at the end when, in a postscript, I discuss what Kabarak Law School, Kabarak, can do in search and in defense of radical legal education. Upon reflection, we all get huge doses of legal education in communities we are brought up. I was brought up in the early 1950s in a community of about 1,000 people at Kilonso, Central Division of Kitui, now Kitui County. The community owned land, grazing pastures, shared resources equitably, settled disputes peacefully, with a keen eye on the reparations and the stability of the community. We practice traditional Kamba religion. Without a doubt, there was traditional Kamba education touching on every aspect of a community's life. When it came to gender justice, as children, we were not only exposed to patriarchy, but also to its resistance by our mothers, who are always with us when our fathers were invariably away. This status quo was changing because of the British colonialism. I went to a secular school, but there was another school run by the African Inland Mission in the next village. Education was not divorced from religion. Indeed, joining school meant joining a religion. I grew up experiencing and reflecting the tensions between colonial education, culture, religion, and authoritarianism, and its traditional nemesis, including resistance. In terms of law and order, I saw the brutality of chiefs and teachers that were in stark contrast with the values that the community brought us up in. All children take position in such a situation. So perhaps unconsciously I was socialized on the side of rule of law and not ruled by law. Justice, fairness, land and resources owned by my community, the village democracy of my community base, or the participation of the villagers, the identification of leaders of integrity, including women, the identification of talents and expertise needed collectively by the community, humane treatment of criminals, including shielding them from the colonial authorities when it was possible. Right in the market close to my village were the offices of the colonial chief and a native court. And one of my uncles was a judge in that court. As children, we occasionally went there as part of our education. The settlement of disputes by the Akamba Kidhitu Oath was known to me before I went to the Faculty of Law in the University of Dar es Salaam a decade later. One can say that I was introduced fully to some of the elements of law in its various fields, but the non-legal phenomena upon which law operated was reflected in the village I grew. So when we say the past indeed is not the past, and that it is invariably the present and future, I can see that radical trajectory in my legal education started from my community and village. A reading of the law. I do not believe I was seduced to read law by reading A Man of All Seasons, that many lawyers of my generation claim to have excited and incited their intellect to venture into the reading of law. I do not believe the visit by then Attorney General Charles Njonjo to Strathmore College, where I was doing my A-levels, had anything to do with it. And I do not believe either it was because Kitile Mwendwa was Solicitor General before he became Chief Justice, and that he came from Kitui. I also knew about a few of my schoolmates in Kitui Secondary School who are reading law in Dar es Salaam. I wanted to read history, the subject I loved. Well, I ended up going to Dar to read law because I wanted to travel outside Kenya and read a discipline that was new. I also knew that there are not many Africans on the bench and in the legal profession. The argument about a bright professional future in the law must have influenced me too. I arrived in Dar es Salaam in July 1968 to start reading for my Bachelor of Laws degree. I was quickly introduced to the compulsory courses in the first year: contracts, legal systems, legal method, criminal law. We had standard textbooks and materials developed by our lectures. What captured my imagination immediately was a course called The Social and Economic Problems of East Africa, coordinated by Professor Saul Pishoto. The book, edited by Professor Isa Shivji, tells part of this story. Indeed, Shivji's chapter in the book, Fathering Constitutions and Birthing Peace, has an outstanding treatment of Pishoto's brilliant contribution to radical legal education at Dar. In this course, Pishoto brought lecturers from other disciplines to teach us. Professor Walter Rodney, in his history lectures, demystified in great measure contracts, legal systems, and criminal law. There were political economists, political scientists, theologians, intellectuals from the freedom fighters based in Dar, ANC, SWAPO, Frelimo, ZAPU, ZANU, MPLA, Mona League, PLO, Polisario, as well, the Black Power, Black Panthers. And I think there is one I put here, the Tuparos, but it's in Latin, and I'm not going to ask Professor Luis to say it. We heard these people either through public lectures at Nkrumah Hall at the university, or directly in lectures on this course. There were rumors that Che Guevara had been in Tanzania, and I confirmed this was so when I later read the biography of his Cuban wife, Aleida March. Tanzania was not called during this period the Mecca of revolution without reason. Dar attracted radical intellectuals from across the world. Students in the university participated and in many instances led this revolution. I write about student activism and conservatism in Dar in the book celebrating the late Professor Hastings Okoth-Ogendo. In some courses, particularly contracts and criminal law, the two American professors, Whitford and Seidman, used the Socratic method that I loved. Since we had materials, the professors simply assigned readings that were to be the basis of discussion. The lectures were study groups where the professor moderated the discussion. Every student had to read these materials because the professors randomly picked students to start off and continue in the discussion. It was my first encounter with collective intellect that shunned individualism and a competition for marks. In these two courses, we had an open book examinations, and there was no need to cram case law provisions or the statutes. All a student needed to do was to refer to their notes and materials. And this methodology requires serious reading of materials to be able to navigate through them for references in the exam that was always 3 hours long. Open book examinations made sense to me because professors teach from the notes, as do practicing lawyers who carry their notes and authorities to court. Crammers and those who prided themselves with photographic memories did not like this methodology. Sadly, In my second and third years, not a single lecturer allowed this methodology. It seems there was a clear tension between the liberal American system and the pulpit British system, where the professor pontificated for 50 minutes without interruption, warning students that the questions will only be discussed in tutorials. This latter methodology encouraged what we then called academic terrorism, devoid of democratic teaching. And needless to say, there was resistance to it. A spectacular incident is still folklore in Dar es Salaam in the quest for democratic teaching processes. One of our professors who taught international law came straight from Dar es Salaam from Oxford University. He had just graduated and was awarded a doctorate degree in law. This professor expected students to clean the board, and when it was not done, he demanded it be cleaned if he was going to lecture. Some students reported him to the University Students' African Revolutionary Front, chaired by Yoweri Museveni, and in one of the lectures, Museveni and two of his bodyguards, even at that early stage, Museveni believed his life was in danger, walked in the lecture hall. They warned the students not to clean the board, and that anyone who did it would be visited with revolutionary violence. The professor walked in. Since he had not bothered to know who his students were, he did not notice that there were 3 students who are not studying international law. He also noticed the board was not clean. This time he proceeded to teach and write citations of articles and cases on an unclean board. It became difficult for the students to write down these citations. There was a murmuring all around. The class which infuriated the professor. Museveni and his bodyguards timed their intervention to perfection. Museveni stood up and asked the professor, who was seated, why he could not clean the board, and I quote, instead of warming the chair with your buttocks. The professor was then lectured on how to treat students as intellectual equals and how his teaching should be democratic. He was reminded he was in Dar, in a country seeking to build socialism. In fairness to the professor, he did see the point and took the criticism to heart and changed. So when you check the trajectory of lives of our African dictators, you will find some redeeming contributions. And the Museveni and Yusuf helped democratize the teaching of law in Dar es Salaam. The course, coordinated by Professor Pishoto, was a welcome distraction from staunch legal positivism that was the mainstay of our courses. I knew how to master the legal rules, master the law, rules, procedure, and study cases and quote them. I also knew that I could not critique legal rules I did not master, if I did not master them. I did not have much time to spend pursuing some of my great insights, the great insights I got from this course. If I had done so, I would surely have failed my examinations. The course opened my mind to interrogate these insights when I would get time and opportunity to do so. And the opportunity arrived when, after getting admitted to the role of advocates and practicing in Kitui for a year, I was able to raise my fees and go back to Dar es Salaam and read for my Master of Laws degree. I chose my 2 courses quite quickly when I arrived in the university in July 1973. I attended a course on jurisprudence that was taught to 3rd-year students. The course was offered when I was wasn't offered when I was an undergraduate. And Professor David Williams, a New Zealander, taught this course. Our main textbook was by Lord Lloyd of Hampstead. The edition we used had added the Marxist theory of state and law. I wrote a paper on the prescription and limitations of actions in my land law course, and I then researched and wrote a dissertation titled The Rent Acts and the Housing Problem in Kenya. I was able to read widely during this period. I attended virtually every workshop that took place on issues relevant to my courses and my dissertation area. I talked to economists and I read their works on landlord and tenant. I discussed my dissertation topic with professors in and out of law faculty. My supervisor, the late Professor Dan Nabudere, made sure I could see any professor he or I thought would help in writing my dissertation. He was also working on a manuscript of his book published in 1977. I met many scholars in what were called Rodney's classes on Sundays. And these classes were great workshops for students and lecturers. In all of them, someone would read a paper and that would be ruthlessly critiqued. It was a sight for a student to get comprehensive reading lists on all manner of topics. Let me hasten to add that these classes were convened by USAF and the Tanganyika African National Union Tano Youth League. Rodney was still around he was still around in 73. He had published How Europe Underdeveloped Africa in 1972. I read this book several times. It gave me a firm intellectual, ideological, and political foundation for studying, researching, teaching, practicing, and publishing scholarly articles on law within its historical, economic, social, cultural, spiritual, and political context. I applied this methodology effectively in my dissertation. I've always found this methodology easily understood by an example I picked from Adam Orchard's, the author of King Leopold's Ghost, a story of greed, terror, and heroism in Africa, where he concedes that he read Joseph Conrad's Heart of Darkness in the vacuum of the real facts in the early history of the Congo. And this is what he writes. It was several decades later that I encountered the footnote, and with it my own ignorance of the Congo's early history. Then it occurred to me that, like millions of other people, I had read something about that time and place. After all, Joseph Conrad's Heart of Darkness. However, with my college lecture notes on the novel filled with scribbles about Freudian overtones, mythic echoes, and inward vision, I had mentally filed away the book under fiction and not fact. In a nutshell, that's a good example from another discipline on how law can be taught, practice, and research devoid of non-legal phenomena, critical to its holistic understanding and analysis. I will now request that I sit down, and I can still come to the pulpit. I actually like the pulpit. Yeah? It's okay? That's all. Oh, okay. Hmm? Yeah, okay. So let me take my handkerchief here. Thank you. Let me, I stopped when I said that what that author said, and it was obviously in literature, about how you can read a novel and ignore the critical facts, the murder and the pillage that was happening in Congo, and focus on the aspects of your discipline that are devoid of facts and context outside that discipline. And Shivji warns of dangers of reversals when the radical paradigms in legal education hold sway. Indeed, they hold sway after contesting liberal law in context, law and development, for example, schools. Professor Yash Guy's chapter in Shivji's book reflects the influence of Da in the following words. The faculty of law was pioneering in many ways, and its influence in terms of the philosophy of teaching and orientation of research spread to other parts of Africa. Kenya, Uganda, Zambia, Zimbabwe, Ghana, and beyond Warwick and Papua New Guinea. Many of us who turned out to be birds, birds of passage, were profoundly influenced by insights obtained in Da. But the fuller working out of these insights took places elsewhere. But these flowerings are also part of the history of Da. As one who also turned out to be one of the birds of passage, I headed back to my motherland to teach law, and I did not leave Da behind. I came back home with a continuously, sorry. Sorry, it's okay. Will you take my phone? Yeah, sorry. Small crisis. So I came home with a continuously developing intellectual, ideological, and political mindset. The teaching of law at the University of Nairobi. University of Nairobi was closed when I was hired in October 1974 to teach two courses in commercial law, namely the sale of goods and hire purchase law. This history of struggles in Nairobi, their seesawing interventions, underground activities, eruptions, is yet to be documented and analyzed. The history involves struggles by the faculty, students, and staff. And when the classes began in January 1975, the university was yet again closed when demonstrations against the state for the murder of J.M. Kariuki took place on 2nd March 1975. When classes resumed after a month, I had already prepared my teaching materials. I applied the DAR methodology to the letter. I could see there was some resistance, which I expected, but also some intellectual incitement and excitement over the new approach. After all, the approach entailed a battle of ideas about the teaching of law. I allowed students to interrupt me and ask questions during lectures. My thought process was not interrupted, as the conservative lecturers invariably said, to avoid exposing their intellectual laziness. and arrogance. Sorry. It's okay. When I did not have answers, I said so. And I went to do research on the issue and gave my answers. When students critiqued me, I welcomed the criticism, and debates ensued. The participation by students enriched our collective intellect in the study of the law. I believe I wrote my early think pieces with a lot of input for my students. 2 of them were published by a student journal, Nairobi Law Journal, edited by a law student, Gitobi Manyara. Tutorials were conducted in smaller study groups of 15 students. Improving on the methodology of DA, I allowed students to moderate the sessions. That required them to work much harder to challenge their colleagues. In one of the sessions, I vividly recall a student who was later to become a judge, looking at the students and asking them, "Why are you not taking down notes?" This comment triggered a debate on what is really a democratic way to teach law. Should the students should the students take down notes on what they thought was important? Could they not simply listen to the jokes of the lecturers who had a wry sense of humor as they sat back and relaxed? I also volunteered, my legal services pro bono to Kituo cha Sheria. I gave legal advice and aid to tenants who had disputes under the Rent Acts, both in residential and business premises. Some students joined me, thereby enriching the experience they gained when they undertook the program that took them to the various courts in Kenya. Lecturers visited the students in their respective courts during the implementation of the program. I kept the system of open book examinations. Some students hated it, arguing that it gave advantage to students who did not prepare in advance. I'd heard that argument in DA, and I demolished it the way it was done in DA. No student was going to walk in an examination and read their notes and textbooks to answer questions. As the system of open book examination was implemented, it gained credence and support. And in the examination, I invariably asked 5 questions. 3 of the questions tested the mastery of law cases and answering strictly legal problems. The other 2 would cover the critique of law. In teaching law courses in the second year, I believe I did not think through what my colleagues. It's okay. What my colleagues in other courses, agency, bankruptcy law, evidence, and land law, were going through. Students would ask them questions about the origin of certain rules, the background to the so-called landmark common law cases, and I proceed to critique the answers given by my colleagues. It did not surprise me one bit when the issue of how to teach law came up and a decision was made to have a seminar to discuss it. And that debate has been captured in a book on law and curriculum development, and my contribution is chapter 2 and is captured the spirit and the word of my teaching approach. Our approach of teaching law within its historical, economic, social, cultural context emerged successfully in that seminar. For me, this meant I could invoke radical schools of jurisprudence, radical philosophies, and radical ideologies in my teaching. I was determined not to use these radical texts dogmatically, but creatively. I confess I started from the somewhat dogmatic persuasion because in the 70s, the ideological battles in Dar es Salaam and Nairobi were clearly marked, and no ideological offenses existed, even for the liberal scholars. Committed to the intellectualism, ideology, and politics of the Marxist school of state and law, I was aware that the trajectory of radical legal education was broad and had contending ideas, and I was to think through as I waded my scholarship in that trajectory. There was various reasons for this success of this broad teaching approach. The law faculty did not exist in a vacuum at the University of Nairobi. The radicalism of students from the departments of literature, political science, sociology, history, and engineering was reflected in the radicalism of the law students. The students had their own study groups that discussed the politics of Kenya, organized demonstrations, and held their lecturers and university administration to account. The University Staff Union, born out of the University Academic Staff Union to include university staff, was resurrected in 1979, and the University of Nairobi became a site of dissent and resistance in the country. The December 12th movement was born and operated underground with the above-ground institutions like the University Staff Union doing the movement's bidding. We expected a political backlash from the state and the ruling class. It started with passports of radical scholars being withdrawn on regular basis. They also return on regular basis that involved going to retrieve them from the principal immigration officer. And on the occasions I went to retrieve my passport, I had to resist the open intimidation that I was subjected to. Then the surveillance followed. You know, the special branch, now the National Intelligence Service, was behind it, helped by lecturers and students who are recruited to the cause of intimidating those students and lecturers that were deemed to be radical in the eyes of the system. Blatant and open intimidation happened before the crackdown, when special branch officers sat in the lectures without registration as students. Some got student cards or student identification cards from the administration when the lecturers and students challenged their presence in class. One of the radical professors in the Faculty of Law, a Canadian, Professor Robert Martin, was charged in court after the JM Kariuki demonstrations in the university in 1975. His charge was that he had behaved in a manner likely to cause a breach of the peace. And this was the first attempt to intimidate the radical faculty. Professor Ngugi wa Thiong'o was detained in January 1978, and he was released on 12 December 1978, when we resurrected the University Academic Staff Union for the sole purpose of struggles to have him resume his duties at the university. We turned this union into one for all the staff in the university and renamed it University Staff Union. President Daniel Moi banned the union on 19 January 1980. He also banned the Civil Servants Union. This ban took place in the application of the marriage of the commander of the Kenya Defense Forces, the late General Jackson Mulinge. We immediately resurrected the University Academic Staff Association that was allowed in the University of Nairobi statutes and continued our struggles. And in May 1982, the crackdown started. The leadership of the University Staff Union was detained, imprisoned, and exiled before the 1st August 1982 coup happened. University students were jailed after the coup. Their leader, Tito Andungosi, died in prison on the 27th of December 1988. It is true that Nairobi University has not been the same again. The state, the ruling class, and the university administration will forever bear the blame for it. It is my hope that both public and private universities will be different and they reflect Professor Mahmoud Mamudani on the role of universities. And I quote him, "Universities, I hope we all agree, are about pursuit of excellence. The reason why universities like to recognize, honor, and encourage expertise. That, in my view, does not rule out democracy in an intellectual setting, for democracy combines acknowledging expertise alongside keeping it open to question, professorships along with peer review. This is why scholarships need to go hand in hand with humility. Expertise is never final. Debate is never closed. This is why vice chancellors should resist the temptation to close debates administratively. He was here talking about University of Cape Town, and why intellectual leadership is not the same thing as intellectual hegemony. In this vision of Mamudani is a basic tenet of protecting academic freedom, in which ideas contend and struggle. And sadly, Nairobi did not allow those of us who searched and defended radical legal education that intellectual space in its university. And sadly, the university administration was complicit in what the state and the ruling class wanted. Let me pause here and briefly reflect on the experience of Makerere University, as recorded in a new book of chapters penned by brilliant legal academics at the university. These academics locate legal education within broad issues of the role of education at Makerere. These issues include education as reflected in the curriculum development, privatization of education, neoliberalism, and the role played by the state, university administration, and political ruling classes. They also discuss struggles by the faculty and students against Makerere as a neoliberal university. As for the School of Law at Makerere, the academics chronicle struggles between and among the faculty of women and men and the university administration, state, and the ruling classes in Uganda. The role played by the faculty union in these struggles is of great comparative importance with similar struggles that took place in Dar and Nairobi. The role of the students in these struggles is also discussed, as is the role of female academics in these struggles. The School of Law, like the ones in Dar and Nairobi, engage in debates about teaching approaches in law, academic freedom, reversals on gains made in radical legal education. And these eminent scholars come up with solutions, or now radical legal education has to be resurrected, and the struggle that has to be waged. I now go to part 4, of my lecture, which is titled "In the Trenches of Constitutionalism, Human Rights and Social Justice Activism." Now, my detention in remand prison and actual detention facilities lasted 16 months, 10 June 1982 to 20th of October 1983. Prison strengthened my resolve to resist everywhere and at all times any attempts of my freedom of thought, opinion, politics, and ideology. Nairobi had fired me after my detention. Luckily, I was able to renew my advocacy practicing certificate for the year 1983, and I started my practice in January 1984. I had a lucrative criminal practice thanks to meeting many Kenyans who are in remand prison and who I helped craft petitions of appeal. I found myself defending Kenyans charged with robbing banks. I got most of them off by challenging the legality of their alleged confessions. It's also during this period that I witnessed the extrajudicial killings of my clients when the police could not get them convicted. And by 1989, all my clients had been killed. It was time to go on and do my doctorate, and I did this. And as I did this, I was able to serve as chair of the Law Society of Kenya. My criminal practice was not without a debate on law and morals. Some counsel whose practice was lucrative because he represented banks and corporations thought I should not defend bank robbers. So we had a debate on the morality of who we represented. And locating the debate on bank robbers, I was able to argue that he represented the big legalized bank robbers, while I represented the poor ones. It was clear to me that where individuals, including legal ones, have rights, they must be defended. However reprehensible their business or occupations are, we must make sure as lawyers that they have due process as decreed by the Constitution and law. I'm sure there is an ongoing debate on whether lawyers should respond positively to applications under Article 35 of the Constitution, that's access to information, on their clients' accounts. The debate on law and morality has never been closed. I arrived at Osgoode Hall Law School of York University in Toronto, Canada in September 1989. I enrolled to read for my Doctor of Jurisprudence. The collapse of Soviet Union happened that year. Now, we were in a global context where there are two major paradigms, socialism and capitalism, were locked up in ideological and political battles. As a student, I was aware that my study would not avoid these intellectual, ideological, and political battles. I chose contracts as my area of study to continue my radical scholarship in Dar es Salaam and Nairobi. Now, in 1988-89, Shivji, a Tanzanian Marxist and a revolutionary intellectual, published a book on human rights. And he argued that human rights talk constitutes one of the main elements in the ideological armory of imperialism. He noted the limitations of human rights as an ideology of resistance. Nabudere, another Marxist and a revolutionary intellectual from Uganda, completed a manuscript that has not been published just before the collapse of Soviet Union. In that manuscript, Namdere helped us understand what had collapsed in the Soviet Union. It was not socialism, he argued, but social imperialism that collapsed. He warned against accepting unthinkingly the argument that radical and revolutionary paradigms of Marxism, Leninism, Mao Zedong thought had given us tools of critiquing the status quo of neoliberalism had collapsed. Indeed, after the great debate among the radicals in Dar, Lucas Kamisi wrote on social imperialism. And in his second memoir, Professor Samir Amin has written how the ruling class in Soviet Union had abandoned the cause for socialism. He wrote, for 30 years, I've said and wrote that if the Soviet system did not engage in leftist reforms, democratization and real socialization of public property, it was condemned to hasten the evolution, even if it were disastrous, which actually happened, towards the pure and simple restoration of normal capitalism to which the ruling class had completely rallied. This was the intellectual, ideological, and political context I was to write my doctoral thesis. Having contracts as my area of study, I chose to study relational contract theory and critique it. After the critique of relational contract theory, also posing the question whether it was a theory, through the lens of critical legal studies and the Marxist theory of state and law, both transformative and anti-status quo, I was able to theorize a jurisprudence of basic needs for all people. I did this through the merger of radical elements of both transformative and status quo schools of jurisprudence. Looking back, I believe I started by being somewhat eclectic, but I discovered there were many scholars who are researching and analyzing the burning question of the time, namely how to creatively and dogmatically and with radical innovation adapt the radical and revolutionary paradigms to the historical, economic, social, and cultural context of the countries of the global South. After submitting my thesis and defending it in 1992, I graduated in May 1993. While in Canada, with 4 Kenyans who are based in the US, we registered the Kenya Human Rights Commission in Washington, D.C. The repeal in 1991 of Section A of the repealed Constitution that decreed that KANU, decreed the Kenya African Union, KANU, to be the only political party, gave us an opportunity to open an office in Kenya. The now christened Second Deliberation was on the march as Forum for the Restoration of Democracy was formed. And in 1991, I was elected the vice chair of the Law Society of Kenya. Paul Muite was the chair. And with the International Commission on Jurists, the 3 organizations became strong supporters of the movement of a new democracy in Kenya. We became an active think tank for the Second Deliberation, as well as acting as mobilizers and organizers for critical political and civil rights that the new movement required. I will not repeat here what I've written in my book on as the great contribution of civil society in Second Deliberation, in agitating for a new constitution We had drafted a model constitution in 1994. We used the model as a critical resource in civic education and mobilization of a new constitution. We emphasized the importance of a people-driven process in the making of the constitution. We contributed in laying the early pillars for the 2010 constitution. The value and the principle of participation of the people, now adorning Article 10 of the Constitution, was born among other rights and freedoms immortalized in Chapter 4 of the Constitution. In the case of constitution making in Kenya, there was robust public participation. Although led by liberal and progressive middle-class groups, lawyers, human rights activists, progressive clergy, media, and opposition politicians, a process was consultative, and the drafts reflected the integrity of what the Kenyan people wanted in their overall economic, social, and cultural developments, and the fulfillment of the promise of democracy. The class struggles occurred among the elite, the middle classes, and the working class. The consensus reached reflected class concessions made in the status quo that was unacceptable and unsustainable. Although the 2010 Constitution addressed issues of governance, social justice, national values, gender, and equitable distribution of resources, it still left intact a capitalistic relations of production, including in international law, pertaining to the protection of private property, national and foreign. However, it brought class antagonisms in the surface as the implementation of the 2010 Constitution started and continued. There was the issue whether the Kenyan elite could implement a progressive, social, and democratic constitution, raising sharply the issue of development of alternative political leadership. There still remains the issue whether, in the hands of progressive alternative political leadership, be it progressive, radical, or revolutionary, the implementation will lay a firm foundation for fundamental transformation. I see this as involving the mobilization and organization of the Kenyan people around the centrality of their will in the 2010 Constitution and struggles against the limitations of that Constitution in the quest to build a new society. All these questions are located and reflected in various sites of struggle. I regard my involvement and experiences in the movement that law sees as non-legal phenomena as critical to the search and the defense of radical legal education. If we agree that constitutions and law are instruments of economic, social, cultural, and political transformation, then such involvement can either enhance the status quo or bring about radical transformation of society. There is a consensus that constitutions are not just legal documents, they are ideological and political texts. Funding constitutionalism, human rights, and social justice. Social justice philanthropy was an ingredient of welfare capitalism after the Second World War. Britain and Europe faced resistance within their borders and the growth of the Soviet Union externally. Even the emerging empire of the US was not spared the specter of socialism and communism. Welfare capitalism, funded by warfare and exploitation of the colonies, mitigated the harshness of capitalism in Britain and Europe. The so-called golden years lasted until 1975, when neoliberalism took root and consolidated during the reigns of Margaret Thatcher and Ronald Reagan. However, social justice continued as the existing club of robber barons expanded to include more foundations. Between 2004 and 2010, I worked at the Ford Foundation. This was a new frontier for me to search and defend radical legal education. The Ford Foundation is an entity that integrated a university, civil society, and also corporate pursuits. As a program officer making grants in human rights and social justice in East Africa, I continued the work I'd been engaged in the East African civil society. This time round, I had the money to support these activities. And by the time I left the Ford Foundation in 2011, I had prioritized my funding on women's rights, bringing in sexual minorities and feminist masculinity. I believe transformation can be funded on the condition that those who seek grants have a transformative agenda, understand the politics and interests of the donors, which are not homogeneous. In East Africa, the struggles for social justice, constitutionalism, and human rights owe a lot, first to the activists themselves, but also to them for knowing which political doors they are going to knock at to have their activism funded. Without the Nordic countries and Holland, their missions in Nairobi and organizations the government funded to give grants to international organizations, the Ford Foundation's Rights and Democracy in Canada, social justice and human rights movements would not have grown as quickly as they did. Without local funding and facing the hostility from our governments, this foreign funding gave us some protection. Activists need a global view of where transformative forces are and where global solidarities can be forged. The Ford Foundation had offices in Africa, Asia, Latin, and South America when I worked there. There were program officers in these offices who were also in the search of transformation and global solidarities. We collectively lobbied for more funds for our programs, where various convenings by the Ford Foundation allows us to travel to various locations of the globe. And such travel gave us glimpses of what was going on in the world. Where we could not visit, we got books, trinkets, T-shirts, and a wealth of outcomes of the work of the grantees from the foundation archives. The lessons I learned working at the Ford Foundation were many. I was able to sharpen my managerial skills that were embryonic at Kenya Human Rights Commission. I was able to interrogate grants, which are contracts. These contracts could be negotiated and varied. They also had elements of accountability, respect, and transparency that bound both parties. I also sharpened my skills of negotiations, mediation, persuasion, and learned from the grantees tools of mobilization and organization from across the various places where the foundation was operating. I also built great contacts, friendships, comradeships with activists in various areas of the globe. I believe I broadened my search and defense of radical legal education through a lot of reading that helped my creativity in reading radical and revolutionary texts. I now come to the judicial experience. The induction of my colleagues and I at the Supreme Court of Kenya by a group of eminent jurists and judges from Canada, Hong Kong, Kenya, South Africa, and the US convinced me that the development of progressive and transformative jurisprudence and the 2010 Constitution was fundamental and a priority for me and the Supreme Court. Making the Judiciary Training Institute the institution of higher learning for the judiciary was going to be critical in this task of developing our progressive and transformative jurisprudence by all courts. This task would also enrich the implementation of the Judiciary Transformation Framework 2012 to 2016. We had a broad outline on the development of this jurisprudence, and it's a story told in the first scholarly article on this issue. At the Supreme Court, we acknowledge that the 20th Constitution is transformative and progressive. It was the basis of transformative and progressive constitutionalism. So, what is a transformative constitution and its constitutionalism? Both a South African scholar and a former Chief Justice of South Africa have defined and written on transformative constitution and constitutionalism of South Africa. The transformative constitutions and their jurisprudence of constitutionalism collectively capture the idea of fundamental societal change through the instrumentality of law. Transformative constitutions depend on fundamentally on which political leadership will implement it. That leadership's political position or leadership's intellectual, ideological, social and cultural, spiritual and political positions become crucially important. That leadership can either consolidate the main pillars of the Constitution while it seeks to rescue its weaknesses going forward, or destroy, overthrow, or systematically subvert it over time. In terms of development of jurisprudence, the idea of transformative judicial politics under a constitution that is transformative is also important. Social struggles, even within the judiciary, impact the objectives of transformative constitutions, either negatively or positively. Ultimately, the core question to be interrogated is whether transformative constitutions under the implementation of radical transformative political leadership can be the basis of a quest for a society that rescues the limitations of transformative constitutions. In other words, are these constitutions continuities of radical struggles, small revolutions that herald better societies? Such questions are important in the context of our planet, where the search for a paradigm that will liberate it from forces that dominate, exploit, and oppress the majority of the global citizens is an ongoing debate and reflection. Thank you. The role of constitutions and the law as instruments of transformation and the agency for developing transformative constitutionalism, its politics and ideology continue to engage us in the debates about its interrogations and demystifications. With the resurrection of radical Pan-Africanism, the question of a progressive Pan-African jurisprudence for the liberation of Africa has also been discussed in the academy. Pan-African institutions, civil society, and various social movements have also discussed it. In the case of Kenya, it's important to note that the Apex Court has described the transformative nature of the Constitution, and this is in a case in the matter of the Speaker of the Senate and another, which is reported in 2013 EKR. And I will just read one paragraph, 51. A Kenyan Constitution of 2010 is a transformative charter. Unlike the conventional liberal constitutions of the earlier decades, which essentially sought the control and legitimation of public power, and the avowed goal of today's constitutions is to institute social change and reform through values such as social justice, equality, devolution, human rights, rule of law, freedom and democracy. This is clear from the preamble, the clause, and the clause that is which recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. And the principle is fleshed out in Article 10 of the Constitution, which specifies the national values and principles of governance. And more particularly in Chapter 4, the Bill of Rights, and Chapter 11, Articles 174 to 200 on devolved government. Paragraph 52, the Apex Clause decided the transformative concept is operational, in operational terms, reconfigures the interplays between the state's majoritarian and non-majoritarian institutions to the intent that that the desirable goals of governance are consistent with dominant perceptions of legitimacy be achieved. As I've said, constitutions are legal, ideological, and political documents, and I believe our 2010 constitution is no different. In terms of ideology, I believe it has a merger of liberal, radical, social, democratic, and socialist elements. In its politics, it puts Kenyan citizens at the core of its supremacy, sovereignty, and centrality. It seeks to transform a status quo that is neither sustainable nor desirable. It lays a trajectory of transformation of all aspects of society by a political leadership that has integrity and is incorruptible. It seeks equitable distribution of resources and the political power through devolution, independent institutions, decentralized, democratized, and accountable arms of government. It seeks to mitigate the harshness and stark inequality of the ownership of land and national resources, which, while focusing on nation and state building based on the country's diversity. Our Constitution as the most modern Bill of Rights in the world that reflects the whole gamut of civil, political, economic, social, and cultural rights. I have published elsewhere 12 specific elements or pillars that make the 2010 Constitution of Kenya transformative and progressive. And these elements include independent and resource institutions, history of our past struggles against colonialism and new colonialism, the integration of formal African justice systems with a transformed informal colonial justice system, integration of international and regional law as part of law of Kenya, independence of the judiciary and judicial integrity, social class struggles in constitution making, the sovereignty, supremacy, and centrality to the Kenyan people in the Constitution, the new jurisprudence under the Constitution, the theory of interpretation of the Constitution, the contested paradigmatic terrain under the Constitution, new judiciary and transformative judicial politics, and that our Constitution is not insular but operates within the context of our world system. At this stage, I have to ask the Vice Chancellor, because I've reached the page 40 of my lecture, that we have a break. Just 5 minutes break so that I can also use the bathroom. Okay, thanks.
We will have one performance. The Director of Music will give us direction in this regard. Okay, so I believe the University Choir will be coming down for that one performance. We'll have a brief interlude and then we will continue with the lecture. Just to reiterate that this lecture that is being delivered today will be published by Kabarak University Press as part of the occasional paper series, and it will be available to you, and we will give you direction on that once it's made available. So we will be distributing copies of the lecture after today. It will be the first publication by the Kabarak University Press as part of the occasional paper series that is being developed by the press. For now, we will invite the choir to take us through their presentation, and then we will continue with the rest of the program.
Vice Chancellor, sir, mbinguni ni raha tupu. Mbinguni raha tupu.
Yesu ndiye ukweli, ndiye njia ya uzima, watu wote humu duniani sifu Bwana. Wakristo wote ni waelezeni Yesu, na huyu Yesu ndiye ukweli, ndiye njia ya uzima, watu wote humu duniani sifu Bwana, sifu Bwana. Mambo ni shwari ukiwa na Yesu wa furaha, tumsifu Bwana twende mbinguni. Mambo ni shwari ukiwa na Yesu wa furaha, tumsifu Bwana twende mbinguni. Basi wa Kenya twendeni pamoja tushangilie, majibu kamili tatoa watu wema. Yesu amerudi, kina mama, watoto, vijana na wazee. Yesu amerudi. Basi wa Kenya twendeni pamoja tushangilie, bila hatupo. Muziki, 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 muziki ya Bwana Yesu. Muziki, muziki, muziki ya Bwana Yesu. Muziki, 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 muziki ya Bwana Yesu. Muziki, muziki, muziki ya Bwana Yesu. Muziki, 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 oh muziki, 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 muziki ya Bwana Yesu. Muziki, muziki, muziki ya Bwana Yesu. Muziki, 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 muziki ya Bwana Yesu. Kenya twendeni pamoja tumuabudu, majibu kamili tatoa watu wema. Yesu akirudi, kina mama, watoto, vijana na wazee. Yesu akirudi. Basi wa Kenya twendeni pamoja tushangilie, bila hatupo.
Halo, halo. Kwa Yesu raha tunayo, hatuna.
Na hiyo bila hatupo, hiyo bila hatupo, hiyo bila hatupo. Thank you very much.
Thank you, Kabarak University Choir. We will now allow Professor Justice Mutunga to continue with the second half of his lecture. Thank you.
I've sorted this out a bit. Thank you very much. In this lecture, I'll reiterate my views in the said publication. The last 6 of these 12 elements that I've read. 1, the sovereignty, supremacy, and centrality of the Kenyan people. The sovereignty of the Kenyan people becomes supreme and central in the implementation of the 2010 Constitution. Executive, legislative, and judicial authorities are derived from the people. The 2010 Constitution provides for national values and principles of governance. They include patriotism, national unity, sharing and devolution of power, the rule of law, democracy and the participation of the people, human dignity, equity, social justice, inclusiveness, equality, human rights, non-discrimination and protection of the marginalized, popular participation in politics, integrity, transparency, accountability, and sustainable development. The fundamental values that unguard all these values and principles are human dignity, inclusiveness, equity, equality, non-discrimination, democracy, protection of the marginalized, and participation of the people. Our democracy and the participation of people are both fundamental pillars of our development. The courts have ruled on what participation of the people entails. This jurisprudence of participation of the people in development has called for robust involvement on the basis that our people think and know of their material needs. The courts have demanded full disclosures of critical information and knowledge on development projects. The sweetheart deals of our corrupt elite are being subjected to this participation of the people. Coupled with the devolution of political power and equitable distribution of resources, the ordinary people have begun to benefit from the results of devolved political and state power to the grassroots. This participation of the people is also integrated in what we call below, without the law, jurisprudence. There can be no doubt in the provisions of the 2010 constitutions about the centrality of the Kenyan people in its implementation. It is this centrality and supremacy that provides the various entry points for robust public interest litigation, as well as the strategic impact litigation. And this litigation is provided for in the constitutions and Articles 22 and 258 of the Constitution. It is one of the great pillars of participation of the people in the struggles for the implementation of the 2010 Constitution and its transformation. The new judiciary and transformative judicial politics under the 20th Constitution. Upendra Baxi, a distinguished Indian radical scholar who is also a progressive organic intellectual, argues that all judges are active, but not all judges are activists. he makes the following distinction. An active judge regards herself, as it were, a trustee of state power and authority. Accordingly, she usually defers to the executive and legislature, shuns appearance of policy making, supports patriarchy and other forms of violent exclusion, and overall stability over change. In contrast, an activist judge regards herself as holding judicial power in fiduciary capacity for civil and democratic rights of all people, especially the disadvantaged, dispossessed, and deprived. She does not regard adjudicatory power as a repository of the reason of state. She constantly reworks the distinction between the legal and the political sovereign in ways that legitimate judicial action as an articulator of popular sovereign. This opposition implies at least one irreducible characteristic of activist adjudication, namely that a judge remains possessed of an inherent power to mold the greater good of the society as a whole. Indeed, this is a context of demystifying decisional independence of judicial officers as well as the institutional independence of the judiciary as a whole. I believe that active judges in Baxi's categorization are also activists for the status quo, while activist judges in his categorization are very active against the status quo. Given societal responsibilities that Baxi correctly imposes on them, they surely must work very hard by refusing to be legal-centric in their approaches. These are contradictory processes because society is comprised of conflicting interests. There are, therefore, political struggles in the judiciary itself based on each judicial officer's intellectual, ideological, and political and social position. Judicial officers should stop deluding themselves that they are not doing politics. Whether their politics emerges from their judgments or their extrajudicial scholarly writings and speeches, judicial officers have consigned the judiciary to what Baxi calls an institutional political actor. And he writes, I believe it's time to take stock and say what judges regard as unsayable, that the Supreme Court of India is a center of political power. I believe recognition of this fact, howsoever belated, is worthwhile to be conducive to the clarification of the political role of the court. And such a recognition will impel us to ask more relevant questions as to what kind of political role the court ought to play in a changing India. In his book, Joe Oloko Nyango, professor at Makerere University, quotes CJ Bagwati of the Supreme Court of India as saying that the Indian Constitution is a document of social revolution. The judiciary has therefore a socio-economic destination and a creative function. Within the title of Oloko Nyango's book, When Courts Do Politics, Public Interest Litigation and Public Interest Law and Litigation in East Africa, are two express questions, namely, do courts do politics, and when when do they do politics? He answers these questions in the affirmative, as seen in the title of the 6th chapter of his book, At the Pinnacle of Politics, Deciding a Presidential Election. I agree with him, courts do politics and do politics all the time. In election petitions, including the presidential election petition cases, judiciary and judicial officers come face to face with the politics of the elite and their political successions. In the case of Kenya, the two decisions on the two presidential elections in 2017 resulted in the Supreme Court being attacked. It's okay. Thank you. Being attacked brutally by the two factions of the elite political parties. These attacks have not abated. One thing is very clear, though. By deciding against both elite factions in both petitions, the Supreme Court, in my view, signaled its independence. It made it clear. It also made a clear statement that it will uphold the Constitution without regard to the pressures the factions will impose on it. How the Supreme Court sustains this position will be critical to the development of jurisprudence, its independence and independence of the entire judiciary and judicial politics going forward. As an apex court, the Supreme Court will have to give leadership on judicial politics so that the judiciary ceases once and for all to be perceived as an appendage of the two arms of government, particularly the executive. The Supreme Court will also have to give leadership against all pressures and influences that can compromise the institutional and decisional independence of the judiciary and its judicial officers. Indeed, the Kenyan judiciary is at a crossroads. It either accepts its historical trajectory of captured institution by the pressures and influences, or becomes the major voice of the vision of the Constitution and the aspirations of the Kenyan people reflected in that vision. In the case of Kenya, my view has been that the Constitution is activist, and I believe our judges and the other judicial officers are all expected to be activists in the quest to implement an activist constitution. Indeed, the Constitution's political vision is not wholly liberal, but has some, as I said, some legal radical ingredients of social democracy and socialism as the ingredients of its objective and purpose. The Kenyan Constitution has a vision for the institutional independence of the judiciary and the decisional independence of the judicial officers. This vision is found in the provisions on the qualifications for appointment, the recruitment process, the chapter on integrity and leadership, and the constitutional decree that judicial power is derived from the people. Judicial independence is for all people. Judicial officers should constantly and consistently ask themselves in whose interests the independence of the judiciary is for. They should also accept they have differing visions of this independence on the basis of their differing intellectual, political, and social and cultural positions. This is the essence of Baxi's contribution to this issue. As such, independence of the judiciary is a contested terrain among the judicial officers that gives rise to its own political struggles. This also means that after judicial officers struggles against the various pressures inimical to their independence, and these pressures are the executive, parliament, corporate, civil society, cartels, ethnic communities, religion, region, family, relatives, and friends. To achieve their individual independence, a further struggle ensues